Welcome once again to Lehto's Law. Here's Steve Lehto.
Josh sent me a note, so Steve, check out this story from Kentucky, WDRB. And we hear about these kinds of stories periodically, and we hear about them often enough to where we go, wait, that happened again? City settles lawsuit after Louisville police raided vacant home, handcuffing wrong couple and child. Now, the home was vacant in the sense that people weren't living there. But these people were there, but they were there with permission, and they had nothing to do with what the police were raiding a home for because they were raiding the wrong home. The lawsuit accuses police of acting on stale information, and without probable cause, and they raided a home in July of 2019 to serve a warrant on a suspect who was not there. And they've settled the case now, agreeing to pay $180,000 to the wrong couple and the child. So Jason Riley wrote this. The city of Louisville agreed to pay $180,000 to a painter, his girlfriend, and her young daughter to settle the lawsuit after Louisville Metro Police handcuffed them while acting on stale information and without probable cause when they raided a home to serve a warrant on a suspect. The man had been hired as an independent contractor to work on the house for a new tenant when at least 10 officers raided the home in military fashion. That's a quote, in military fashion, shooting objects through the windows and breaking in with weapons drawn according to the suit. So I'm suspecting that the things through the windows could have been tear gas, they could have been flashbangs, I don't know what they were, but that would startle you when stuff starts smashing through the windows and the door gets kicked down. House had been empty for a while. The furniture was outside on the curb, and the man had a painting truck sitting out front. And it turns out, and this is how you know the information was stale, the target of the investigation had already been arrested and was in custody. So there's a guy out there, the police want to arrest him, they got a warrant. They arrest him. They have him in custody. Then somebody goes, hey, we got this warrant here, let's go execute on it. Then they execute it at apparently the wrong place, and they're looking for a guy they've already got, and it's the old left hand not knowing what the right hand is doing. And one thing you've got to remember, and don't get me wrong, you can defend against this in court all you want, but one thing is that there's a concept of knowledge that can be attributed to an organization. The same way that if you know something, I can expect that you know it. Well, if the police department has somebody in custody, they should know they've got the guy in custody. And you can't go, well, they knew, but they didn't know. The whole organization should know. And so, especially when they're about to go out and do something where they, break windows and bust doors, they should at least double check. Is there call me crazy, but I've got an idea here. You should have a checklist before you go and do something like this. And job number one should be double check the warrant. Is it still outstanding? Or is it now, it's been withdrawn because we got the guy. He's in our custody. So the man and his girlfriend initially believed they were being robbed and feared they'd be killed. The couple and their daughter were handcuffed for about 20 minutes. Now, the way that's written, it says the couple and their daughter were handcuffed for about 20 minutes. My clients are pleased to put this terrible incident behind them and have some closure, said their attorney, who represented the couple. The Jefferson County Attorney's Office, which handles lawsuits against the city, did not immediately provide a comment or request for the settlement agreement. Case was dismissed after both sides reached a settlement, according to court records. So the parties can reach a settlement, contact the court, and say, we stipulate to dismiss this case, and then the court will look at it and go, fine, we'll dismiss the case. The settlement itself does not get filed with the court usually. However, because it is a municipality settling a lawsuit with taxpayer money, the amount of the settlement will often become public. The lawsuit was actually initially dismissed in March when a federal judge ruled that police had produced enough probable cause for the judge to sign off on a warrant. But the U.S. Circuit Court of Appeals overturned that ruling in May, finding that the home had been vacant for several days and the suspect already had been arrested and was in custody when officers raided the house in the neighborhood, shooting objects through the windows and breaking in with weapons drawn. And again, I don't blame a judge who's presented with a bunch of affidavits that are sworn by law enforcement. They say, look, this is what we got. We'll swear to this in court, and that's probable cause. But I'm assuming underlying all of this is there is this person that we're looking for out there. We need a warrant to arrest that person. Okay, but once you've got him in custody, you can stop trying to arrest him, right? I mean, so it's almost like they're poking around like anything we can hang this on. The higher court found that the officer who applied for the search warrant had inadequate training, and the department has a history of improper searches. The district court erred by finding that no constitutional violation occurred, said the three-judge appellate panel. The man in the house told officers he'd been hired to paint the house and pleaded with them not to handcuff his girlfriend or his child. Officers proceeded to handcuff all three and then separated them, according to the ruling of the appeals court. A search of the mostly empty house yielded no evidence of any criminal activity, and officers joked after discussing their fruitless search that it revealed the old setting up the painter's trick, whatever that means. A U.S. District Court judge had previously ruled the warrant proved the alleged drug dealer had been to the home before it was vacated, and evidence could have been found there. Thus, no constitutional violation occurred in the issuance of the warrant. You realize that anything is possible on some level, so they could bust into any house and potentially find evidence there. They could, but when they don't, you got to go really, really strong on the side of, okay, don't tell me what could happen. Maybe let's look at what did happen or what is likely to happen, right? And so because evidence could have been found there, they didn't find any, and the house is vacant. It's being painted by people who had nothing to do with this? Yeah, no. The appeals court found that the suspect police were looking for did not live at the home, was never seen conducting any transactions there, and had only visited the person who lived there weeks before the search. So following this logic that they were trying to argue, if a bad person visits your house 3 weeks ago, and now the police want to arrest that person, they can bust into your house like this, military style, break stuff up, handcuff the people they find there, and go, well, but there's a bad guy here 3 weeks ago. He visited this house once 3 weeks ago. And when you have all the furniture outside and people painting, your first indication, again, this might take some really, really deep detective work to figure out, but maybe the house is changing hands. Maybe. I don't know. A lot of my ideas are really out there, okay? The officer who wrote the search warrant testified he had not had any formal training on warrants in more than 6 years and did not know whether the police department policies required him to determine who lived in the home. So again, let's back up now. The officer who wrote the search warrant, meaning he wrote out what he wants the judge to sign, testified he had not had any formal training on warrants in more than 6 years and did not know whether the police department policies required him to determine who lived in the home they were getting the warrant for. When police arrived in 2 armored vehicles and at least 1 ATV, the house had been empty for days. That ATV is a tricky thing. I mean, armored vehicles would scare me. ATVs, not so much. Within seconds of shouting out a demand to exit, police shattered and then shot something through the window. And the man said, out of nowhere, we heard like banging on the doors. We didn't know if it was somebody trying to get in or somebody looking for someone who used to live there. And then the police treated us horrible. I mean, worse than if we were what he was looking for, talking bad about us, and cussed her out for getting upset, apparently referring to his girlfriend. And so it's a crazy situation. But I've done now, I think this year, 3 or 4 videos, maybe more, on police executing warrants at the wrong place. Now, here the address was correct, but they shouldn't have gotten a warrant for this address, among other reasons, because they already had the guy in custody. You'll recall not so long ago, the Institute for Justice was involved in a case where The police showed up and they realized that there was something wrong, so they broke into the house next door. And it turns out that was not the house they wanted either. They should have gone the other direction. And there's no excuse for that. And so the weird part is that the guy was in custody. You would think that somehow, I don't know, maybe the police department should invest in computers. I hear computers track this stuff. How do they not know they've got the guy in custody? And so the good news is that it scared these people and shook them up, but nobody got seriously injured. It could have been much worse. I know people, and I'm just talking at random here, I know people where if somebody were to start kicking down their door, who wouldn't wait to see who it was before they responded. And then it gets really ugly. And then you try to figure out what happened. It's like, oh, they were trying to arrest a guy who's already in custody. You're like, what? So $180 is real light here. But they apparently agreed to settle for $180,000. And so I assume that their attorney's going to get some of that. And so I'm not sure how they're going to divide that up because there's obviously 3 people, 2 adults and a child. But can you imagine being a child in this situation? So Josh, thanks for sending me. That's a fascinating story. I hate to hear about stories like this in the sense that it happened, but at least the couple and the child, they filed a lawsuit. It's settled now. And I have a lot of people, and hear stories like this. They go, oh my gosh, they settled for so little. They should have held out for more money. It's really, really hard to stand in someone else's shoes if you don't know them and understand what it is that they're going through or why they would settle here. And don't forget, this case was thrown out of court once already. So the case got thrown out, on appeal got reinstated, brought back down, and now they settled. And there might be a fear on their part that this is either going to take forever or it might never pay off just because they could drag it out and someone else might throw it out. So to settle for $180,000, I think it's low because I've heard of cases that settle for much more, but I don't blame them for taking it. That's the point. And so almost always when you hear about a settlement, both sides, if it's a good settlement, usually think they got ripped off. Plaintiff wants more money, defendant wanted to pay less money. Okay, it's probably a decent deal because both sides gave up a little bit. So Josh, thanks for sending it for WDRB. City settles lawsuit after Louisville police raided a vacant home and handcuffed the wrong couple and child who were in there because the man was painting the house for the people who were about to move into it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It's a sort of glass half full, glass stops existing in time and space kind of deal.